And Phil Federico, if you are ready to go, I will just tell you we have a great courtroom advocate and trial lawyer in Phil Federico from Baltimore, Maryland. And Phil has gone to verdict in virtually every kind of tort case you can imagine. I got to meet him years ago when he traveled down to Florida to try a very difficult medical malpractice case, and he was just on another planet as to how wonderful he was in jury selection, opening statement, and throughout the trial. And he came to down to our part of the state and got an extraordinary verdict. But he doesn't only do the one-off cases, the product liability or the med mal or the trucking case. He has had tremendous experience and success in the class action world, in the water contamination world, where he's done a number of those case projects over the years, now doing the Lejeune project, and also in the mass tort arena. But this is a very high energy lawyer who is totally engaged in everything that he does. And he's very analytical in the sense of trying to identify not just the minefield, but where are all the mines in the minefield, and how do we navigate that, coming at it from every which way. So it's great that we have him here with us today. Great lawyer, great person, great friend to all of us, Phil Federico from Maryland. Phil?
Thank you, John. It's really nice being here with everybody this afternoon. It's quite an introduction. I hope I can live up to at least a small part of it. And I've learned a lot over the years from lawyers like John and Howard, who have really forged a path for us. So without further ado, let me jump into the filing of the case and the navigating of this litigation, and see if we can pull this up here and get going. So what I want to talk about initially is, and before I do, clearly you've heard things more than once today if you've been here with us since roughly 9 o'clock this morning. And I am going to repeat a few things at the risk of boring people, and I apologize for that in advance. But to the extent that you're hearing something more than once, it means it probably really warrants being said more than once. It's probably pretty important. So bear with me if you hear something for a second or even a third time. I know that Sarah Papantonio this morning talked a little bit about what we do before we actually file the lawsuit, and John explained to us the difference between a claim and the actual lawsuit itself. So I just wanted to touch on briefly, before we actually file our lawsuits in the Camp Lejeune litigation, there are a couple hoops we have to jump through, and the act under Section 804H talks about this, and it talks about presenting a claim to a federal agency, and that the claim needs to be denied in writing or and sent by certified or registered mail. So where we really go from there is we file a claim form, and we've attached the claim form here as Exhibit 1. It's in your materials for you to look at. And I don't want to spend a great deal of time. The form is pretty self-explanatory. There is a section I want to draw your attention to, and if we could go back for a minute, and it's the section that deals with the amount of the claim. Sarah talked about this morning, and she gave some examples of amounts that their firm is using to fill in for the amount of the claim. The U.S. Code, Section 2675, does limit your ultimate recovery to whatever you put in this form. The one thing I want to mention is it says, except where there's an increased amount based on newly discovered evidence. Well, we would have the burden of proof when it comes to newly discovered evidence. I don't think any of us would want to try to jump through that hoop, if you will. So certainly I would lean on the side of picking a bigger number as opposed to a smaller number. But it's going to vary from case to case, depending on how strong your case is on causation and how significant the damages are. Talk a little bit about limitations and deadlines, if we can move to that. And you have heard this before, but it bears repeating again. And Sarah said it, and I think others have said it. This is a really unique case in that it is driven by a statute. And it's really driven substantially by a statute, and all you have to do, it's like my law school professor used to tell me, just read the rule. In this case, just read the statute. The statute is very well written. It does a very good job explaining the rules of the road, so to speak. So you need to file your administrative claim within 2 years of the enactment of the act, and that would be August 9th or 10th, depending on your view, 2024. So certainly everybody is out there doing client acquisition, vetting clients, vetting cases. There's no emergency to go run and file your administrative claim. Immediately, there is plenty of time. And then in terms of filing the lawsuit, certainly once your claim is denied, you need to file it within 180 days or 6 months of your claim being denied. We don't know whether or not any of these claims are going to be denied within a 6-month time frame, but certainly if they are, then that starts the clock running, if you will. Certainly once you get past the 180 days, if the claim hasn't been denied, then we believe you're in a position to file your lawsuit at that point. It's a little unclear as to how quickly after that time frame you need to file. If the claim is never addressed administratively, I would recommend certainly doing it within 6 months. I don't see any harm in that. So once you get past limitations and you're filing your claim, the strategies regarding claims and really this is the strategy that ultimately leads to the lawsuits that are being filed in the Eastern District of North Carolina. One thing I'd like to emphasize in talking with John and Ed and others in leadership is that I really think the ultimate goal from 50,000 feet, if you will, in this litigation is to try and establish as best we can, as high a baseline as we can for the value of these cases based on the recognized health problem or the alleged damage or medical injury. And the best way to do that is through bellwether trials. And the best way to get the best bellwether trials is by filing the best cases early on. So again, I think there's a lot to be said for vetting your cases carefully and communicating with others in this litigation. And I think we all should make our best effort to try and file the cases which are strongest on not just causation, but damages as well. I do think that it's very unusual that you're put in a position where you get to take on a case as a plaintiff's lawyer and you don't have to prove liability. That doesn't happen very often. If there is a tendency to sort of focus just on damages, I would highly recommend, especially after listening to Howard's presentation, that you don't do that. I think you need to evaluate your causation. And again, I would recommend filing cases with the strongest causation possible and the most severe damages first, so we can have the highest baseline across the board for the various categories of cases that are involved. So if we talk a little bit about the complaint itself, the complaint very much, as I said before, is a function of the act and really needs to comport with the act. And so under section B, 804B, I would recommend the language in red, the quoting verbatim in every lawsuit. So it's, as we know, it's people who resided, worked, or otherwise were exposed for not less than 30 days between 1953 and 1987. And the language otherwise exposed, if people worked and used the water there, there could be no end of people who are actually not Marines or veterans who might qualify under this section. If we look forward to the burden of proof in the act, as Howard just did a great job explaining in detail, this language should be included, I think, in the lawsuit very clearly. And I think, the words in red should be included verbatim. There's a relationship between the water at Camp Lejeune and the harm that the plaintiff suffered. And then I think if you look at subsection C2 of the standards, it says subsection A, a causal relationship exists. And I would put that language in there. And I would say and/or sufficient to conclude that a causal relationship is at least as likely as not. And the reason I would do that, I would hearken back to sort of what Howard was saying, and that is the science is evolving, and the science is going to continue to evolve in the coming years. And I think there are many cases now where we meet that sufficiency standard, but there are cases that maybe we don't at the moment, but we will later. And the science could, in some rare cases, go in the other direction. So I would allege both. We have attached a complaint for you all, a sample complaint, and it's pretty straightforward. It's really not rocket science. There's an introductory section. We talk about the parties, jurisdiction, and venue. We do recommend alleging that you've met the conditions preceding to filing the lawsuit. Your factual allegations you should have the general allegations that form the basis for the case and specific allegations factually that relate to your client. The case is a one-count shootout. It's a creature of statute. So as John was saying earlier, no need to get creative, no need to allege negligence, no need, keep it simple is our recommendation. Certainly within count one, which is the act itself, these bullet points here are the things that you want to include. There will be a claim for relief. And this is a really interesting issue, the issue of demanding a jury trial. As best I can tell, there's nothing in the statute that affects your right to a jury trial. The statute doesn't specifically create a right to a jury trial. So I'm not quite sure where that leaves us. I certainly hope that we wind up with a jury trial. It remains to be seen, I guess. All right, so where to file? And I know you may have heard this before. I'll just go through this fairly quickly. It's in the Eastern District of North Carolina. The Act says they have exclusive jurisdiction, and there are divisions within that Eastern District. And so if your plaintiff resides in the Eastern District, you should file the case within the specific division where they reside. And if your plaintiff does not reside within the Eastern District, you should file the case in the Southern Division. Now, if you go to local rule 40.1 and you have a client who resides in the Eastern District, it will tell you what the various divisions are within the Eastern District and where you should file. Now, I want to talk a little bit about this cover sheet, not dissimilar from the administrative sheet, terribly dissimilar at least. The only thing that's a little tricky is under nature of suit. We recommend that you go to the section 360, personal injury other, and it's already filled in here, but under the nature of the cause of action, you will see that it refers to the act. The U.S. District Court Eastern District website has a lot of information about the do's and the don'ts, and I highly recommend if you're getting involved, that you read it. It's well done. All right, let's move on to the MDL issue, and I know that Ed touched on this a little bit earlier, and as have others. And as a plaintiff's mass tort lawyer and one who does a fair amount of environmental litigation and groundwater contamination litigation, my instinct tells me, boy, this is an MDL, but obviously it's not, because there's only one district from which these cases can be filed and tried. So clearly, it's not going to meet the criteria to be an MDL, although it may look like an MDL. So where does that leave us? Well, really where it leaves us is with Federal Rule of Civil Procedure 42, which talks about consolidation and separate trials. And the reason for that rule, frankly, is cases like this one, where you have common questions of law or questions of fact amongst a multitude of individual cases that have been filed. And so the court can, under Rule 42, A1, they can join for a hearing or a trial, any and all matters at issue in the action. They can consolidate the actions or issue any other orders to avoid unnecessary cost or delay. I interpret that as pretty broad language. I think it would be pretty difficult to prove that a judge abused their discretion in consolidating or not consolidating various portions of the case. I do think that the argument of judicial economy, when you're talking about as many, hundreds of thousands of lawsuits, maybe more, and you're talking about one court and however many judges are available, it's a major undertaking. So I do believe that there should be, I think, some natural effort made to do some consolidation, pragmatically at least. So I do think that the case lends itself, as Howard was talking, it reminded me that the general causation in this case does raise a lot of common questions of law and fact based on the scientific literature that's out there. So I do think that where causation is concerned, certainly there's great room for consolidation. And then when you have similar injuries or the same injury amongst a large group of people, again, I think there's some room for consolidation, but I don't have a crystal ball, so it's a little hard to tell where we're going to land on that. If we next talk about discovery itself, anybody who's tried a case or handled a case in federal court, the rules are pretty straightforward. Rule 26 is a good place to start. Certainly, there'll be initial disclosures. You'll have to do your interrogatories, your request for production of documents. You are going to want to find fact witnesses. I think that's going to be important. And I'll get into all this in detail in a minute here. And there's going to be the need for your Rule 26 expert reports and expert depositions, and eventually, hopefully, a settlement negotiation or trial. So talk more specifically about discovery and things that you ought to be thinking about. Again, I mentioned there's no need to prove wrongdoing. So don't get all caught up in trying to prove that somebody did something wrong or really waste your time and energy on that. But a lot of what would normally go into proving wrongdoing in a case, and in this case, if we had to prove it, you're going to need those documents and those facts to help you prove causation, I think. And what I mean by that is you want to develop similar facts for causation in terms of the source or sources of the water that was being used, the time frame within which the exposure was occurring, and the degree of contamination in the groundwater from that source during that time frame. So there are a variety of sources here for exposure. The time frame is going to vary from client to client, and the degree of contamination in the varying sources is going to be different as well. So you need to be in a position to try to really develop that information during discovery. And one of the things I would highly recommend is that you do your discovery in collaboration with your causation experts. You're going to be using environmental engineers, hydrogeologists, and those are the people that are going to tell you what facts they need to underscore the opinions you want them to give. They have to have an objective basis. It has to be factual in nature. So use your causation experts to help you draft your discovery, both general causation discovery and specific causation discovery. So with regard to the written discovery and interrogatories in particular, it is my recommendation that you look for potential fact witnesses, people that were there at the time. Ask your clients, ask their family, and who was there at the time who could provide any factual information in terms of where the water was coming from, the frequency with which it was being used, what kinds of things was the water being used for in the house or in the yard. And also in the interrogatories, we're going to want to know a lot about the monitoring that was being done of the water, past, and certainly the variety of health studies that are out there. Same with requests for production of documents. Interrogatories I've found throughout my career are usually sanitized by the lawyers who are drafting the answers, and they have a way of spinning them such that they're not very helpful unless they want to give you information that could help you. But the request for production of documents is altogether different. I mean, the documents are what they are, and there's really nothing that a lawyer can do other than give them to you. And again, your experts should know with specificity what kinds of reports, what kinds of health studies, what kinds of groundwater studies and monitoring data based on the rules, the regulations, the protocols during the different time frames should be available. And there's a great variation between 1953 and 1987 in terms of what people were doing to monitor the water that was being used at that point. So again, for fact depositions, you're going to want people with personal knowledge of the facilities, the operations of the water facilities in particular. When we get to the experts and the expert reports, remember that you're not only going to need your causation experts, you're going to need damages experts, and they're going to get deposed just like they would in any other one-off case, or for that matter, mass tort. Moving to exposure, and again, I've always been a fan of preparing for the worst and sort of hoping for the best as a plaintiff's lawyer. I've always felt that, when I'm in a room and I'm on one side of the table, and even if I have, co-counsel with me, typically there are 3 or 4 times as many defense lawyers on the other side of the room. So maybe that's the basis for the plaintiff's lawyer's paranoia, so to speak. But, I don't think any of us are going to be upset if we over prepare for these cases as we prepare them for trial, because while every case is not going to be tried, there are going to be some that I think are going to be tried. So exposure to the contaminated water is something that's necessary to prove. And step one is really just a more general exposure or general causation. And what we're talking about there is basically that the water that was reaching your client needed to have come from a contaminated source. You need to prove with specificity exactly where the water came from. So you've got to draw a direct line from where the water was sitting originally to being in your client. And you need to do that through factual discovery and through expert testimony as well. Then you need to prove for exposure how much your client was consuming. Now, who's going to remember with specificity? And I've been through this before in other groundwater contamination cases, and frequently what a person will say is, I don't know exactly how much water I drank, but back then there wasn't bottled water. Nobody's drinking bottled water. And I would go to the sink, 6 times a day, 8 times a day, 12 times a day. The important thing is they have to have an answer. The higher the number, certainly the better, consistent with reality and the truth. But they can't have no answer to that. And other exposure is important. Bathing, I've talked to some people who would wash their car 2 or 3 times a week because they had a beautiful car and they love to wash it. So again, just look behind every door, if you will, and try to create as much exposure as you can. Here are the 3 hot spots in terms of locations: Hadnot Point, Tarawa Terrace, and Holcomb Boulevard. So here are some things you're going to want to ask for or look for each individual client. Certainly you'd like that. Their testimony is going to be important. If they're not around, You certainly want the testimony of any family member or even close friend who they may have served with, who can give accurate testimony regarding use of water, consumption rates, and the like. There is the double D 214 form that speaks to where people were stationed and their time in service, specifically at Camp Lejeune. Try to get a hold of that. Their service record, you want to try to get a hold of that. And employment records are very helpful. And you should be able to get the DoD, Department of Defense personnel file for your clients. So those would be all important things. Now moving to step 2 of exposure to contaminated water. And this is really the more specific causation, if you will. We want to prove that the water itself that your client was ingesting or exposed to was polluted, but also what the pollutants were and what the levels were. And you're going to need not only the documents, but you're going to need a hydrogeologist and environmental engineers, because these opinions, these call for expert opinions. They're not an opinion that a layperson can give. And we can't assume that anybody's going to take judicial notice of anything. So we need experts to talk about the contamination, fate, and transport, and address the sources of pollution and the fate and transport of the specific pollutants that were affecting your specific client. Certainly the ATSDR report, which Howard just went through, is a very helpful tool. It provides a lot of modeling and analysis. Your experts should be intimately familiar with it. It should provide a substantial basis for much of their opinions. There's also a website that's available, and we have it here. You should probably take a look at that. Moving on, establishing the proof of harm or injury. So now that we've established causation and we really need to talk about the injury, we are recommending that there's sort of general causation again and specific causation as to the injury itself, and showing that there is a relationship that is recognized in the scientific literature between the TCE or PCE or benzene or vinyl chloride or some combination thereof and the health condition or conditions that your client has is very important. But it's also important to not stop there. It's also important to look at specifically the medical records and to have an expert prepared to talk about the medical records. And the kind of expert that we would recommend would be an expert who would deal with whatever the injury is. If it's a cancer, you're going to want an oncologist. And so we think while there's plenty of literature out there to help us and support us, we do believe we could see some Dahlberg challenges, which we need to be prepared to deal with. Moving to the next slide, I want to discuss more specifically really what you're looking for to prove your injury. A toxicologist and or specialist, and you'll probably need a toxicologist in most every case. And then, as I said, based on the injury, you're probably either going to want an oncologist, neurologist, fertility specialist, or the like. Not only are you going to want them, and as John Romano said earlier this morning, get your medical records now. There's no reason not to. You're going to need them. The more time you spend with them, the more time your expert spends with them, the better. And certainly you're going to want to send your exposure reports from your causation experts to your damages experts, because that will help them form the basis for their opinion. You're going to want to have an IME performed if it's a kind of injury that lends itself to an IME. And some of the other things that your medical experts are going to want to consider is the timing of the onset of the disease relative to the exposure. And this is something that a lot of people haven't talked about yet, but I think it's going to be very important. And that is, are your medical experts able to rule out other commonly known etiologies or causes for whatever the condition is? I mean, if you're third generation kidney cancer and your father, your grandfather, your great grandfather all died of kidney cancer, and you're a plaintiff in this case and you have kidney cancer, that's not as good as if you have no family history of kidney cancer. So to the extent that things can be ruled out as possible etiologies, it will make specific causation easier to prove. I would mention that some of the best experts that I've ever worked with in my career, I met by virtue of the fact that they were treating physicians of my client. And there's certainly plenty of people out there that have testified and are well known. But again, I would encourage you to talk to your clients' treating physicians. They're not always going to be willing to help, and they're not always going to be good. But occasionally they are, and they have enormous credibility when it comes to proving your case that a hired expert just can't have naturally. Economic damages. I think we all have had experience with this. I won't spend a great deal of time. All your past medicals, you're going to need to get a hold of them. You're going to need to think about the future costs associated with the prognosis, treatment, and medical monitoring moving forward. Medical monitoring in general is not, as I understand it, a recognized claim in North Carolina. But if you have a diagnosis and the treating doctor says your condition needs to be medically monitored, that's different. And you would be entitled to be compensated for that. Some of our clients certainly need life care planners, especially if they have a terminal prognosis. Some of our clients can no longer work because of their injury. You're going to need a vocational rehabilitation expert for some. If you have a total lost wage claim, you're certainly going to need an economist for that and to reduce damages, economic damages to present value. So the prospects for resolution, I don't have a crystal ball, but common sense dictates, I think, that where resolution of this case is concerned, why would Congress pass an act where they were trying to right a wrong and take care of these people, and then put up years and years of defense? So hopefully this case will resolve favorably, hopefully sooner as opposed to later. And John, that's about all I have.